thank you all for coming, and I just want to talk to you a bit about European citizens. Many of you will have European nationals working with you, and even though Brexit obviously is not finalised yet, and we don't know the final deal that's going to be offered and made to Europeans working in the UK, there are some things that the government have told us we can do, and we are advising employers should do at this early stage. So the first thing to look at is who is affected by this. Obviously, EU nationals, and those are the European Economic Area, so those are people from Liechtenstein, Norway and Switzerland. And it really affects people who are living in the UK and working here as in employees or self-employed people, people who are self-sufficient, people who are job-seeking, people who are studying. All of those European nationals will be affected by Brexit, and their ability to stay in the UK could be, shortened or even curtailed, depending on the outcome of the negotiations, which, as we know from this morning, have not yet been concluded. So the types of application that they can make include applications for permanent residence and applications for registration certificates, and this really affects people who have been here for 5 years plus, 5 years or more, or people who have been here for up to 5 years, and very importantly, family members of those people, because you will have situations where people are in the UK based on a family member who is a European citizen and therefore able to work and live here. I don't know, for example, a French national is able to bring their non-EU family member with them who also has the right to live and work here. So the purpose of making an application for permanent residence or registration is to show that you as a European national are here at a particular time and have the ability to stay here should you make the correct application. That would enable not only your family members to stay, but it may enable you in the longer term to make an application for naturalisation as a British citizen, i.e. get a British passport, or registration. I'll talk a bit more about that in a little while. But in other words, to make your situation as a European citizen certain here, best to make any application you can as early as you can. So in order to show that you're exercising these so-called treaty rights, i.e. as a European national working, self-employed, etc., in the UK at a particular time. So it affects people who have been in the UK for 5 years or more, for those who have been in the UK for less than 5 years, and for those who, for example, may have arrived after the date of the referendum on the 23rd of June 2016. So in terms of practical considerations and safeguards and what can go wrong, I mean, if you don't have the ability to remain here at the point of Brexit, either permanently or for an extended period, that lack of evidence could mean that you as an EU national could become subject to immigration control in the same way as non-European nationals are now. So the failure to make an application at the right time could catch you out, and it could also catch out your family members who may be non-EU nationals. The future obviously is uncertain, and so we're advising make any application you can as a European national. Don't ignore Brexit, despite what the government say, or make any assumptions, because it is clear, and Theresa May has indeed confirmed this, that freedom of movement will end. She confirmed that in January. And so applications can be made and should be made. There's likely to be a big rush of applications as the situation becomes clearer, so make any applications that can be made as early as possible. Just a quick word again on naturalisation. I mean, citizenship is the only sure way that you will be able to remain in the UK indefinitely. Think about it, for example, in terms of European nationals who've been here for 5 or 6 years, and particularly in terms of children who want to be able to stay on, because children, those under 18, will be eligible to register as British citizens as soon as either one of their parents becomes permanently resident here. They don't need to pass any tests, they don't need to have been here for a particular amount of time. As soon as one of their parents gets permanent residence, they can apply to register as British citizens. So what are the new proposals? I mean, the first thing the government have talked about is this so-called settled status, which is, as far as we understand it, a new type of permission that's broadly similar to permanent residence. And I guess the important thing to emphasise here is that the UK's offer to include settled status has been made with the expectation that reciprocal rights will be afforded to all of those Brits who are living in the EU. So until those are agreed, the settled status and the other rules that the UK are proposing cannot be accepted or finalised. But until the date of Brexit, freedom of movement will continue and will continue to determine the rights of EU members and their families in the UK. But after Brexit, UK law will apply, and those people are likely to have been removed from the jurisdiction of the ECJ and to have to qualify under our current immigration rules, which I'm sure you're all aware are a lot tougher and stricter than those applicable to Europeans. So this new settled status will, as I say, be largely similar to permanent residence. EU nationals will need to meet specific requirements. They need to show that they'll have been resident here for a continuous period of 5 years, and they'll also have to pass an assessment of conduct and criminality. And broadly speaking, there'll be 3 types of EU migrants who are affected. So those who arrived before the cut-off date, which I'll go into in a moment, before the cut-off date but who have been here for 5 years, those who arrived before the cut-off date who have been here for less than 5 years, and EU nationals who arrive after the cut-off date. So what is this cut-off date? I mean, it's the date on which we assume that European law will no longer apply to European nationals, and the UK's current immigration rules will determine the fate of those who are here as Europeans. That date has not yet been determined, but the UK have confirmed it will not fall before the 29th of June 2017, on which Article 50 was triggered, and it won't fall after the 29th of June 2019, when we leave the EU. And what the UK are proposing is that there should be a grace period. So for those who arrive before the cut-off date and who have been here for 5 years, they will automatically be able to apply for settled status. And they will need to do that even though they already have permanent residence. There will be another application they need to make, although it should be, and we are assured it will be, a light touch and simple application. Those who have arrived before the cut-off date and who've been here for less than 5 years will be afforded a grace period of up to 2 years at the moment, they're saying. So they should apply for an extended leave to remain under this grace period, and that will enable them to eventually apply for this settled status. Those who arrive, however, after the cut-off date will need to apply under post-immigration rules, and we don't know yet what those say. So if they arrive before the cut-off, after the cut-off date, but before the UK exits the EU, they should be allowed to stay during the grace period, but that has not yet been confirmed. And again, I'd ask you to look at the family members of Europeans who are living here, because if they are going to be seeking to join their family member after Brexit, they will be subject to the same rules as those applicable to British citizens now, and those rules are much tougher. For example, the European family members or the non-European family members of European nationals will find it much harder to meet the immigration rules. There are maintenance requirements. There's a much narrower definition of family members. Currently, as a European national, you can bring all sorts of extended family members into the UK with you. You will not be able to do that as a European national after we've left the EU and our post-Brexit immigration rules apply. So, what are the points of contention? Obviously, the first one and most obvious one is that the cut-off date remains undecided. We're not going to be able to know exactly what people can do until that cut-off date is decided. And secondly, of course, there is this talk of an online light touch system to apply for settled status. But you know, how will that work, and how many applications will they be able to decide quickly? It surely means that there will be more delays. I mean, I've read somewhere that with the amount of time currently taking the Home Office to process applications, with the amount of applications that they are expecting from the EU, it could take them 47 years to get through all of the applications they have to get through, particularly those which require discretion to be exercised. If, for example, an applicant's circumstances are not particularly straightforward, for example, if they've had a lot of absences from the UK, or they spend a lot of their time outside of the UK, even though their home and family life, for example, may be here. So those applications won't be able to be decided quickly, and that's why we would urge, make those applications as soon as you can. I mean, as I'm sure you're all aware, the EU are unhappy and have been unhappy about our proposals. Michel Barnier called the proposals a damp squib, and they considered that the UK are just basically chipping away at the rights of Europeans here, and they're basically treating them as third country nationals already. So how will things change? We don't know yet, definitively. All the more reason, therefore, for making any applications you can at the moment as a European national, in advance of new immigration rules coming in. What these will look like and when will we see them, not yet known. Likely that some indication will be given in the course of 2018, but certainly worth making any applications you can now. I guess it's worth saying as well, I mean, it's implausible, isn't it, that they will be that draconian and extreme. It's not likely that 3 million people will be forced out of the UK, but it does seem no better offer than that outlined above, with the settled status and the grace period is going to be offered. So make any application you can now as a European citizen. So what can you do now? How can you prepare? I'll look at it, first of all, from an individual point of view, and then looking at employers, what employers should be thinking about. So in terms of individuals, make those applications now for permanent residence or a registration card. These aren't difficult applications, but they are fairly cumbersome. And there are ways you can do this without having, for example, to relinquish your passport and let it disappear into the Home Office for 6 months. It can be done fairly quickly, but the correct supporting documentation has to be collected. An online application has to be made. You need to collect evidence that you have been in the UK for 5 years or more if you're making an application for permanent residence. That means putting together one document per year for the 5 years from a so-called official source. So that might mean tax document, pay slips, bank statements, etc. I mean, there are various anomalies you need to think about as well. If, for example, a European national has been here at any point as a student, they are required to have had private medical insurance for that period of time. I have seen, and the Home Office have confirmed, that they are not refusing applications based on the fact that someone doesn't have private medical insurance at a particular time. But, you know, you don't want that to delay or cause questions to the application, so best to put them together. And the other thing to remember is the documents need to be originals. So best to advise European nationals, start collecting your documents now. They need to be originals. The Home Office will not accept copies. A lot of people have asked us about travel and how much they need to, how much detail they need to give about how much travel they've done. They won't need to give it at the permanent residence stage, but certainly when they come, and if they do come to naturalise and get it, in order to get a British passport, they need to provide details of their travel covering a 5-year period. So it's best to start putting together schedules of that travel now. And it's only really significant, frankly, in terms of whether your application is going to be refused or accepted if an applicant has been away very regularly or if they've spent more than 6 months out of the UK in any one 12-month period. And again, I'd say, in terms of individuals, if they know they want to stay in the UK and if their current national government allows it, think about applying to naturalise as a British citizen. It is the only way they're going to be able to stay in the UK, definitely, forever, if that's indeed what they want to do. But there are issues they need to consider. For example, not all countries allow dual nationality. Most do, but many do not. And, for example, Germany will allow dual nationality, but only if the other nationality is one from the country of the EU. So what will happen when the UK leaves the EU to German and British nationals? It's also fairly expensive to apply for naturalisation, and you need to give the authorities confirmation that you, as the applicant, have every intention of remaining and staying in the UK indefinitely. So it has to be your main home, and they have to have proof of that. They will not issue a British passport to someone for convenience sake, for example. So what about employers? What should employers be thinking about? And what steps should they take? I guess there are 5 things they really need to do. We would urge them to do this because it will enable them perhaps, hopefully, to get ahead of the rush. The first thing, I guess, is to undertake an audit. Who are your employees from Europe? What's their situation? How many of them, for example, are here because their partner or spouse is a European national? Are they here on that basis? Assess if there's an area of the business that may be affected disproportionately by those in senior, for example, senior roles who are Europeans. Are there any critical roles that are affected, and how will they be affected going forward if suddenly those people have to leave the UK or they have to be relocated somewhere because they haven't been here for 5 years or they haven't made the application they can at the correct time? Communicate all of those findings with your workforce generally in order to be supportive, proactive, offering guidance. And finally, review everybody as early as you can. I mean, if you are a licensed sponsor, you are required to do that anyway under the Prevention of Illegal Working regulations. So it is something that you all can undertake as early as possible with a view to mitigating complications and fuss later on. I mean, I guess it's worth saying, it is likely that at some point all European nationals who are here in the UK now will be affected by the changes. I mean, they're bound to be. We are going to leave the EU. So the Home Office, the UK Visas and Immigration, are going to be tough with these people, not least because, for example, our current government have said that they promised to bring down immigration numbers and they're to meet much lower targets. So they're going to be tougher than they have been, and they're going to use the opportunity of Brexit to do that with Europeans here now. The other employees to think about are those who are regularly on secondment. I mean, those people are likely to be affected in terms of their ability to apply for permanent residence. For example, I know that there are a lot of people that commute regularly into the EU. Their home and family may be here, but they may go into the EU, for example, during the week, which means that they will have been out of the UK for longer than is allowable for permanent residence. Those people, as I think I said earlier, will need discretion to be applied to their cases, and so it's worth getting those cases in as early as possible. And finally, for business travellers, those who are travelling regularly into the EU, not necessarily for work permits, but to work there and therefore need a work permit, but just on business visits. I mean, again, take care of the amount of days they are out of the UK in terms of their ability later to apply for permanent residence and settled status. Just a word quickly about UK citizens in the EU, because I'm asked a lot about that. I mean, obviously, many of you will have British people who are working in EU countries and trying to decide what will happen to those people. It's worth saying, you may well be aware, the EU does not have one immigration system. Each country has its own system, and so permanent residence and citizenship rules vary from country to country. And is it worth, for example, getting someone a work permit now for the country to which they travel regularly and work in, rather than waiting until they're forced to do so after the UK leaves the EU? And as I say, those rules vary. In Germany, for example, it's 8 years. You need to provide evidence of 8 years residence before you can qualify for citizenship. In Sweden, it's 5 years. The rules vary. Just before I finish then, just a quick word about Irish nationals. I am asked about this a lot, and obviously there are many, many Irish nationals in the UK, and they are members of the EU. However, they're not affected by anything I've mentioned above. That's because we have a common travel area with Ireland, and their right to be here is also governed by the Ireland Act 1949. Both of those, that and the common travel area, obviously predate the EU, so they are not affected. They don't need to do anything.